It is a red letter day here in America, my friends. The Supreme Court has now ruled on the presidential immunity case, and they have ruled in favor of Donald Trump. And heads are exploding all across the fruited plains and, of course, all over social media. Now, one of the key rulings or key points on this ruling that I want to touch on here is the separation of powers and why the Supreme Court's decision is game-changing here. The Supreme Court's ruling addressed the separation of powers in several key ways. First, it recognized that the president has some immunity from criminal prosecution for official acts taken while in office based on separation of powers principles. The court was emphatic that this immunity is necessary to protect the independence and effective governing and functioning of the executive branch, and they are right here. If a president cannot make decisions based on the fear of what his successors might do to him after the fact, effectively it would end the power of the presidency altogether. They would just become puppets. And because of this, the Supreme Court made it clear that for the president's exercise of core constitutional powers, the immunity must be absolute. This prevents Congress from criminalizing or the courts from examining the president's actions that fall within his exclusive constitutional authority. Now, for other official actions, the court also ruled that presidents are entitled to at least presumptive immunity, although the court did not definitively decide whether this should be absolute or presumptive immunity. Now, the Supreme Court also stated that the president is not above the law, but that prosecuting official acts would improperly intrude on executive authority. It also rejects the government's argument that the president has no immunity, stating that this would improperly subject presidential decision-making to potential prosecution. And another thing worth noting here, the Supreme Court also remanded the case to lower courts to determine which alleged acts qualify for said immunity, providing guidance on distinguishing official and unofficial acts. So, in essence here, the ruling seeks to preserve separation of powers by shielding certain presidential actions from prosecution while still allowing prosecution for unofficial acts. So let's see what this breaking news got from reactions in the media. Let's pull up an article from the New York Post. This is by Ryan King, and it is titled Supreme Court Affirms Absolute Immunity for Official Acts in the Trump Case. Ryan writes, the U.S. Supreme Court ruled Monday that former President Donald Trump enjoys absolute immunity from prosecution for official acts during his presidency, although it left the exact extent of that protection for lower courts to decide. The High Court's 6-3 ruling vacated an earlier decision by a D.C. federal judge and cleared the way for more appeals by Trump's legal team that could set the trial schedule in the 2020 election case against him back for months or years if it ever happens. John Roberts, in his ruling, wrote that the president enjoys no immunity for his unofficial acts, and not everything the president does is official. The president is not above the law, but Congress may not criminalize the president's conduct in carrying out the responsibilities of the executive branch under the Constitution. The president, therefore, may not be prosecuted for exercising his core constitutional powers, and he is entitled at a minimum to a presumptive immunity from prosecution for all his official acts. Robert added that immunity applies equally to all occupants of the Oval Office, regardless of politics, policy, or party. Now, lawyers for Trump, who is 78, they write, appointed 3 of the 9 justices on the Supreme Court, unfurled a legal theory of sweeping protection from prosecution for any acts undertaken while in office in a bid to quash the 4-count case against the former president. Now, the 45th president is accused of criminally attempting to defraud the United States by using dishonesty, fraud, and deceit to obstruct the electoral vote process, impede the January 6th congressional proceeding at which the collected results of the presidential election are counted and certified, and working against the right to vote and to have that vote counted. The former president's camp claimed his efforts were official acts protected by his office, but special counsel Jack Smith argued that they are still subject to criminal prosecution. Now, initially, many legal experts posited that Smith's position against absolute immunity was a slam dunk and anticipated that the Supreme Court would spurn Trump's plea for a get-out-of-jail-free card. Why they would think that, I really don't know, and the article doesn't say, but let's move on. But during oral arguments before the top court in April, it was clear that its conservative majority was agonizing over the question, seemingly hunting for some sort of middle ground and insinuating that the lower courts didn't do enough due diligence on it. Arguments from both sides lasted about 2 hours and 40 minutes, which is notably longer than usual. The conservative justices fretted that tossing out Trump's immunity case carte blanche could pave the way for politically laced tit-for-tat prosecutions against presidents down the road. Naturally. Justice Neil Gorsuch wrote, Justice Neil Gorsuch said at one point, "I am not concerned about this case, but I am concerned about future uses of the criminal law to target political opponents based on accusations about their motives. We are writing a rule for the ages." The justices mused that most prosecutors are easily able to get a grand jury to hand down indictments and fretted that an absence of any presidential immunity could be destabilizing because chief executives would become prime targets for such tactics, and of course they would. I mean, what are we seeing now? And let's see, they go on to write that in the run-up to the top court's decision, President Biden stayed largely mum, but said he can't think of one reason why presidents should have total immunity from prosecution. Now, the New York Post goes on to write that Trump didn't need to win here. They said former President Trump only needed to delay the case because of the upcoming election, and he succeeded. If he wins a second term on November 5th, he could theoretically tell the Justice Department to unravel the federal cases against him. Another possibility, Ryan writes, although an untested one, is that Trump could attempt to pardon himself. So that's the long and the short of it from the New York Post. Now, Trump did react to the Supreme Court ruling, and he released a statement about the Supreme Court's decision on his immunity case, in which he wrote, "Big win for our Constitution and democracy, proud to be an American." Meanwhile, the Biden campaign reacted to the Supreme Court ruling themselves, and a senior Biden campaign advisor released a statement about the court's ruling on the immunity, stating, "Today's ruling doesn't change the facts, so let's be very clear about what happened on January 6th. Donald Trump snapped after he lost the 2020 election," I love that term, we snapped, "and encouraged a mob to overthrow the results of a free and fair election." The campaign argued that Trump thinks he's above the law and is willing to do anything to gain and to hold on to power for himself. Fascinating. Well, my friends, breaking news. We will certainly be keeping an eye on this story as it develops. From the To Be Frank show, I am Adrian. Thanks as always for watching, my friends. I will see you all next time.